All right, so of our panel of attorneys, Bill, do you think you're ready to answer a question, or do you want more time? Think you're ready? He probably wants more time, but...
Yeah, give me an easy one.
Okay, all right. The opposite of that, but we'll see. Why can villages be their own Act 51 agency but not townships? And then what other differences are there between townships and village government? If you could not get a broader question, that would be a good one.
Okay, so we'll just sort of compare and contrast townships and villages. And the first part of the question deals with Act 51, and Act 51 basically is the road money that comes from the state and is then distributed to various units of government, including MDOT, the county road commissions, the villages, and the cities. So villages end up being treated...
Maybe they're calling in a last-minute question. We can still take it. I'll take it.
Oh, yeah, everybody wants that Fitbit. So villages have their own roads, and they control their roads, just like cities do, just like county road commissions do, just like townships don't. But if you missed my presentation yesterday, then I'm not going to go over that again. So since a village controls its roads and is responsible for those, it does receive the Act 51 money, or a portion of it. But there are quite a number of other differences between townships and villages. I haven't seen a lot of townships wanting to become villages recently. In fact, what I'm seeing is, for the most part, those entities that are villages are considering becoming cities, and some have recently become cities. There's also a possibility for villages to look at the option of becoming disincorporated and going back to being a township. There are so many problems, in fact, with villages right now that I would consider villages to be, in many cases, an obsolete form of government. They're another level of government that is extremely narrow. They don't do everything like townships do. They add another level of cost to local government. They can do many of the same things that townships do, but honestly, if you're a township and you're thinking about converting to a different form of government, I would think that you would be better advised to skip over the village step and go straight to a city. There are a lot of advantages of being a city, including the ability to have higher tax revenues, but I don't see any advantage, honestly, to going from a township to a village.
Okay, well, obviously we're township attorneys. You can see we dissuaded anybody on that one. Okay, so we actually have quite a few questions on medical marijuana and recreational marijuana. We'll spread them up. But in the room, who's already got medical marijuana ordinances in place? Oh, wow, a good contingent. Okay. And recreational, adult use? Okay. Okay, so Matt, if you got the microphone, I got a good question for you here. This is like the question that we get all the time as it relates to establishing authority for medical marijuana. As it relates to medical marijuana under the 2016 Act, if we do nothing, will it affect our township? And then there's a follow-up question. Hold on, I'll throw this on to make it more complicated all at once. So do we have to adopt an ordinance, or can we just leave it alone?
Right, so on the medical marijuana, you do not have to act. That's a strict opt-in. So if you have not adopted a medical marijuana ordinance, then you're fine. It will not be permitted in your township as a medical facility. But that's not the case. Now we have, on the recreational side, it's a different situation. On the recreational side, you do want to put an ordinance in place because it's badly drafted because it's a citizen initiative and there are lots of problems with it, which I'm sure we'll get into more. But the stronger reading of the Recreational Act is that it's an opt-out. You have to affirmatively opt out and say you do not want recreational establishments in your community. And we've seen lots of townships do this. And there's a lot of good reasons to do it, too. The Laura was given a lot of authority under the Act to really control how these recreational establishments are going to come into play. And even if I mean, it passed right throughout the state, so that says most of our communities then likely voted in favor. But even when your community voted in favor, that doesn't necessarily mean they voted in favor of marijuana establishments on their street corner. I mean, that initiative did a lot of things. It allowed local growing, it allowed possession, it allowed use, and it created a recreational establishment facility. The piece we can touch as townships are the establishments, and we can say for right now, we're going to wait and see how that goes through the regulations, let that get settled before we reassess whether we want to allow the establishments. And we can put those in an ordinance so that it's clear to the public as well. But you cannot take away the right that's now enshrined in state law for them to possess some marijuana and to grow their own 12 plants. So that's now a legal use for 21-year-olds, and that's in the state act. So be a little cognizant of what that change in the law means. Yes, we can prevent someone from selling in your street corner, and you want to put that ordinance in place so that when Laura comes and asks you, hey, is this a permitted use in your municipality, you can say it is not. We've had that ordinance in place, and it's effective prior to the application that you received.
So I two follow-ups that are related to marijuana. We can address those. Somebody asked the question about what's the proper spelling of marijuana. So if you look at all of the federal statutes refer to it with a H. Then when the initial state law initiative was put in place in 2008, also in the 2016, they spelled it with an H, and then everybody else spells it with a J. And the question was, what's the difference? And the most is interesting, I just a week ago heard from the director of the Bureau of Marijuana Regulation, and he was indicating that he would have actually preferred that they had spelled it with a J because he gets so many emails, comments, and actually calls every week from people asking why did they spell marijuana wrong on their website. So the interesting thing, they used to have a disclaimer on their website which basically explained the origin of marijuana spelled with an H, marijuana spelled with a J. Their basic premise was federal law was spelling it with an H, we're going to do the same thing. Now they've taken the position that they can't change state law, obviously, and they can't change the voter-initiated legislation, so they decided to make it one step more complicated, and on their website and in their own forms, they would spell it with a J, but when they refer to the state law, they would spell it with an H. So now, to hedge your bets, they've spelled it both ways. The other question then that Matt, related to the issue between this interplay, right? So we get a lot of questions about the interplay between the 2016 commercial recreational statute and then the voter-initiated 2018 statute, and how adult use, the licensing of those facilities, interacts with municipalities that have already opted in or allowed medical marijuana facilities. And so the question basically comes down to, if I've already opted in, I'm allowing facilities and have facilities operating, and I have not yet made a decision on recreational marijuana, or if I have prohibited them, can recreational facilities automatically operate in my township, right? So basically, if I opted in to commercial medical, can recreational facilities come in and operate?
Unfortunately, the answer to that question is we don't know yet. The first thing I would say is that if you're allowing recreational establishments, you do, under that process, you can require a separate application. You can require a separate application fee and push that right. So if you're allowing it and they're saying, hey, I've already have a medical one, that's good enough, you say, no, this is a completely different law, and look right here in this statute under Section 6, I get another $5,000. So that's step one. But the more interesting and potentially problematic question is, when you already have your medical facilities, you've allowed potentially a few facilities, you see some medical benefit, but there's an argument under the way the language was written that a grower, processor, or retailer can co-locate with any existing marijuana facility. Well, so okay, the idea, what we think the intent of this was just to allow some co-location and to try and keep some economies of scale, right? You don't want a recreational establishment right next to a medical establishment. That just wouldn't make sense. We'll put them in the same building. But the way they've drafted the language, now we have a conflict with the township's right to prohibit them entirely. And until we've seen a rule come out of Lara and potentially some litigation over someone trying to force the issue, it's not exactly clear which provision there is going to control. So what we would recommend you do if you don't want them, if you have facilities but you don't want the recreational establishments, is to pass your ordinance prohibiting the recreational establishments, and then, hopefully we'll get some guidance from the regulator and kind of massage and control that as we see this language get interpreted and actually put into use. But it's going to take some boots on the ground and people putting things in place before we really know how that language is going to be used. And hopefully it'll be used in a local advantage, and we think we have some strong arguments that we can deploy in your favor to help continue and contain those land uses.
And the practice pointer there, too, just to add on, if you're somebody who has a medical marijuana licensing ordinance and you're allowing facilities, since there's potentially this where we would have to basically wait for a court case to rule on this conflict in the language, what I would suggest you do is if you do prohibit recreational facilities, at least include something in your statute that would indicate if for any reason under state law or otherwise recreational facilities were permitted, they are subject to the same rules and regulations of your medical marijuana facilities, right? Because the worst thing you'd want to do, prohibit it, have somebody declare that those facilities can go in, and then they're not subject to any potential regulation other than state licensing. So you could at least subject them to your rec ordinance or your medical marijuana ordinance, and then we could go back and at least fix it from there. Okay, so Carol, we're going to answer your question, but if I answer it, you can't now leave because you ate lunch and then you're good to go. But I'll answer it early so we get it out of the way. Okay, all right, I'm just making sure. So, Jake, we're going to look at what defines a public works project, and then we're concerned about basically the cost for if we're resurfacing a parking lot, the additional need for a licensed professional engineer to oversee those projects.
Right. So a public works project is something that's pretty broadly defined, and the actual meaning of it can kind of depend on what statute you're looking at. But in any case, repaving a township parking lot would certainly qualify as such a project. As to whether a licensed professional engineer is required, the question mentioned MCL 339-2011, and under that statute, there are specific requirements for projects requiring a licensed engineer, and essentially what the statute says is that if you need to have a licensed engineer, they need to be licensed, they need to be involved in certain steps of the project, such as surveying. But there is an exception for projects that cost less than $15,000. So if the repaving project in question is under $15,000, no engineer is required. If the project does not require a professional engineer, you don't have to meet the requirements of the statute. But if the project exceeds that cost and requires a professional engineer, then you need to comply with that.
So you'd have to repave a pretty small parking lot.
Yes.
Especially with current construction costs.
Yes.
Okay, Kyle, I like this question. So I like all the questions, but this one especially. If a trustee uses a personal laptop for viewing packets and accessing township email, can the laptop itself, is it subject to FOIA? And I think just an add-on to that, which I see a lot, is so I also use my personal laptop with the packet on it, and I take it to the board meeting. How's that play out under FOIA?
Right. So this is a kind of interesting question. I guess to start off, FOIA is not necessarily Big Brother. You kind of think about, this question kind of alludes to a laptop being subject to FOIA. FOIA covers public records, which are defined in the statute as writings, kind of electronic correspondence, stuff that townships and municipalities are making during the course of their official functions. So if a township official is using their personal laptop to do work, like create board packets and stuff, the board packets are subject to FOIA, but not you don't have to give your laptop out to somebody to inspect as a public record. It's the files, it's the official documents, and the writings under FOIA.
So wait though, if you've read enough cybersecurity articles, you should just be deleting all of your metadata, right? I mean, nobody wants metadata circulating. It's crazy. I'm kidding. It was a joke. So ultimately, I think that what FOIA is going to provide is you produce the record in the form in which you have it stored at. So if you have it stored and the metadata is in there, then you're going to be producing it in the electronic format. So they could potentially read that metadata. Hopefully that answers your question. Okay, so for those of us who know Ross, I'm going to channel Ross because we got a few tax questions, and this was a pretty interesting conflict between what potentially the STC is doing in a recent decision from the Michigan Tax Tribunal. So the question that we got is, can an unmarried surviving spouse with a veteran's exemption, can they sell their house and buy another one in Michigan? Will then the unmarried surviving spouse be allowed the exemption? And the interesting thing is, so obviously the exemption itself doesn't benefit the property. It goes with the actual veteran or surviving spouse veteran as a qualified exemption. The way that the STC looks at it is, since it's to the personal qualified individual, they can move to another home and still obtain the exemption, including the surviving spouse. Now, the interesting part about it, though, is there's a recent decision, as I spoke to Ross just yesterday. This decision is on appeal, so I guess we'll wait to see what changes or how this construction works out. But the tax tribunal issued a decision in Rayburn versus Farmington Hills. They basically said that a surviving spouse cannot claim the exemption in another home if the subject property was not previously homesteaded. So they read the statute and basically disqualified them for that purpose, but otherwise you could transfer that veteran's exemption. And then if we had any follow-up questions, I would have to defer to Ross, and he's not here, so we'll write them down and email him. Okay, our next question, Jake. So we get a lot of questions about, I mean, this is true with almost all of the boards or agencies that serve in townships, is the composition of members of your ZBA, your PC, who can you appoint to the Board of Review, who can you appoint to the ZBA, and then of course with the Planning Commission, ZBA, and Board, you have a lot of offices that are being filled by potentially individuals serving on both boards, right? Some of it's even mandated by statute to have that liaison between the township board and the different authority or the different entities. So can an employee serve on the Planning Commission? So can an employee of the township serve on the Planning Commission?
Yes, that would be allowed under the Incompatible Offices Act.
And then is the board member appointed to the Planning Commission allowed to, is there any difference as to who could be the Planning Commission chair? Are there any limitations?
Yes, so the Planning Enabling Act provides that one member of the legislative body of the township, which is the Township Board, is actually required to serve on the Planning Commission as an ex officio member, but that same member is prohibited from serving as the township or the Planning Commission chair.
And then the other interesting question is, apparently somebody's committing this violation because they asked us, if we already approved a bunch of business, now what do we do, basically? What's the repercussions? I would say the first thing is that we probably shouldn't have announced it in this room, but I won't relate the question to the township, so hopefully no one finds out. And we don't advocate just sweeping it under the rug, right? So yeah, so what do we do?
The Planning Enabling Act it does not really specify what kind of corrective action is required for that sort of violation. If you look under the Incompatible Offices Act, it basically gives a court the discretion to void acts taken by that official, but certainly does not guarantee that that will be the result. So if challenged, a court could void actions taken by that official, but it'll be up to the court.
So probably fix that. Don't make any more decisions. Okay, so Kyle, I got a good question. We get a lot of interest as to why everything someone has to do in a township, they got to have a land use permit in a zone township. So the question that we got is, basically, I own property in a township, and why is it that I always have to get a land use permit for everything that I do, including things that don't require a building permit?
Right, and this is an interesting question, I guess, to start off. The premise behind the land use permit, and which may also be called a zoning permit in other places, is to determine compliance with the municipality or township's zoning ordinance. And kind of the compliance terms are, does it meet the setback requirements of building a shed somewhere? or for example. In this case, to determine what the specific requirements for a land use permit for individual township, you'd have to look at the township's zoning ordinance. So it's everybody's kind of least favorite answer. It depends in this case. You can have scenarios where you don't need a building permit, but you do need a land use permit because you need to determine the land use compliance, like compliance with setbacks and the other requirements in the zoning ordinance, but you don't need a building permit to build something, say, like a fence or something minor. So that would be kind of the answer to that question.
And of course, your other thing is that everybody's ag exempt. So, right? I can tell I have a lot of people that look at building permits. They must hear that all the time. Then you ask them to attest to the fact that it's ag exempt, right? And then it's just crickets. It's like, wait, I'm not going to sign an attestation that it's used for ag. Okay, Bill, I know this is pretty interesting. You actually did this. I don't remember if it was this year or last year. Someone wants to know, what about the ability to crowd raise for a fundraising project? Now, this is asked in the aspect of maybe fixing up the park or doing some type of community entertainment, but I know that you actually had a similar approach, parallel done with respect to litigation and trying to offset some costs. So can you do it? And if you got any other insights or thoughts about it, that would be helpful.
So yeah, this wasn't my idea, but the township came up with the idea. This was a very, very expensive lawsuit for the township against a international corporation that had basically sued the township over a land use decision they made, and the township really wasn't in a good position to fund the litigation. So they did a GoFundMe to raise money to basically pay my legal fees. And they raised a lot of money. So
you can see we like crowdfunding.
Now, the question that was raised, however, by the requester was, well, what if you do that and you don't raise a lot of money? What if you don't raise the amount that you needed to, say, build a park or something like that? Can you then just use it for something else? And the answer to that question would be no, because if you used it for something else, you would have gotten that money under a false pretense, right? And actually, your obligation, if you do crowdfunding and you don't ultimately use the money for that purpose, is you have to give the money back to the people who contributed it.
And the interesting aspect of this is that you can crowdfund to help raise litigation for your own litigation, and then I just had the reverse where an individual that we were pursuing crowdfunded to raise legal fees to continue to defend appeal against us. So I guess it goes both ways. My other thought, Bill, while you're on it, because I think this is something that you've probably dealt with a lot, is we end up getting hired and then we get in these interesting conversations with the different elected officials and employees of the township as to who can speak to the township attorney and whether there are any obligations to involve the entire township board, right, as far as what's coming from the attorney, or whether it can be a single individual, maybe a supervisor, clerk, and so are there any kind of like legal parameters around that, and then obviously any recommendations?
So the first, I mean, there's so many different pieces to this, and I won't address all of them, but let's talk, first of all, is there a legal obligation for the entire board to receive the attorney's, great wisdom? And the answer to that question is no. If there are situations in which you believe that it's appropriate for that to happen, we can arrange to provide that advice to you in a confidential written legal opinion, which would allow us in a meeting to go into a closed session to discuss that confidential written legal opinion and maybe pursue it in some greater depth, because really you should be able to talk with your attorney and ask for, a detailed explanation of why you can or can't do a particular act. And you don't necessarily want to do that in the open where you're giving away your legal strategies. Just like anyone else who's entitled to a confidential attorney-client relationship, the township board is also. The other part of it, though, is that, and I think this was the main question that was being raised, well, who's allowed to talk to the attorney, and when can they talk to the attorney? And that ends up being really a policy issue for your township board. You need to decide that. I would say that it's extremely dangerous, at worst, costly certainly, if everyone on your township board has the ability to pick up the phone and call the attorney anytime about any issue that's on their mind, because attorneys bill by the hour, and so all that time that they're spending discussing questions with your board members is going to end up on your legal bill at the end of the month. You want to manage your legal costs in a more efficient way, and I think most townships at this point, what they do is they will appoint one person or two people to be the contact with the attorney, so that when an issue comes up, that they can efficiently get those questions answered, and that there can't be a legal bill being run up really high without the board knowing what's going on. That doesn't mean that it isn't important to ask for legal help before you do something. It's almost always easier to fix it before it happens than to try to go in and repair damage that's been done by some act that's been taken. But I think you all need to have an efficient process for communicating with your attorney that you're comfortable with, and you need to do that as a board as a matter of policy.
Okay, so Matt, I know you've recently dealt with this, and to set this question up, how many here have county zoning? They don't have their own zoning, they're under county zoning. Okay, just a few, because most of you probably know maybe there's a better way to do it. No, you can leave it in the hands of the county, I'm kidding. But, so to set this up, of course, the question ultimately is, if you are a general law township, the county does the zoning, okay? And then the question is, they pass an ordinance the township doesn't agree with. A big surprise, conflicts between two local entities. They want to know the extent to which they could promote or assist in a referendum of the zoning amendment to change. It's a solar use. They want to stop the solar ordinance going into place, basically. And they want to know what type of involvement could they have in basically helping citizens have a referendum of the county's ordinance.
Right, so the main thing is to be cognizant of your different roles. You can be a citizen, you can also be a township official, so which hat are you wearing? As a township official, you can certainly help advise on policy, and we have our meeting on Tuesday night. Public comments start sharply at 7. Be there and invite your friends to be there and make noise. So you can get on the record, you can get people's attention, you can have folks at the meeting who are then building support. But that's just using the infrastructure that's already there for the purposes it's set up for, public comment at your meeting. You can also go out and you can collect signatures and you can raise awareness and try and advocate against this. But if you do those activities, you want to make sure you're taking off your government official hat. If you're going door to door, you want to say, I'm here in my, as a citizen, as a concerned citizen, wanted to talk to you about this new county ordinance. And don't use any township or government funds or resources when you do those things. So I would even advise against don't make copies at the township hall, right? You want to make it as clean as you can so that someone doesn't try and find a gnat, and then try and blow a molehill into a mountain that then becomes a bigger headache than the actual copy, which only saved you 15 cents anyway. So you can use your time and energy and the connections that you have throughout the community, but use them as a private citizen.
Your other option is to pass a zoning ordinance, right? Then you just don't have to deal with it. Then it's a whole different set of headaches that we have questions about. So related to those townships that have passed their own zoning, right? We'll talk about those problems. Kyle, as it relates to zoning violations, we run into this problem all the time. So I have a property, it's in violation, and then you write me a ticket. And it gets noticed for a day to go to court, right, the pretrial or the formal hearing. Before I get there, I conveniently quitclaim sell it to Bill. So now Bill owns the property. Of course, I didn't tell him that the township's after him because I have a blighted house on it. And then what I do is I call Kyle up right before the hearing. I like to wait just like an hour before, too. Like, I don't want to call too early because I want to make sure the township attorney's still driving there, right? Then I call Kyle up, and I'm like, hey, Kyle, I don't own it anymore. What are you going to do?
So this is a frustrating scenario, and then also kind of somewhat comical scenario. So for civil infractions, for kind of zoning violations, they're not necessarily associated with the property. It's the person who possesses and controls the property. The problem here, though, is when you look for remedies, because a lot of these people, I'm sure, as you're all aware, a lot of the people with code enforcement problems, they don't necessarily fix their problems even after a judgment's entered. So you want some type of injunctive relief. And to get injunctive relief or putting a lien on the property, you generally want to go after the legal owner of the property. So what you can do is you can dismiss the tickets and enter new tickets against the new legal owner. I would hedge this, though, if they keep this quit claiming, like, they play hot potato with the property. Eventually, you're just going to have to show up to court, and the judge will probably see through that, and you'll probably get some sort of relief that is helpful in that scenario.
And I think the other thing, too, because we've, so far, we haven't had to play hot potato with someone too long before the last person's holding the bag and we've got to court before they called us and said, I don't own it anymore. But potentially there are some other resolutions where you could get some affidavits recorded in the chain of title so that then even when the quitclaim deed goes, you basically put everybody on notice that we're, prosecuting this property. Because that's kind of the issue, right, with real property. It's that you've got a pending matter going on in court. It's got the parties' names on it, but it doesn't really tell you what property that relates to. So if I quitclaim to Bill, he really doesn't have any way to search other than if he were to go to the court, he'd have to then search my name and then see if my property's listed in violation. So there are also some ways that we could record some notices in the chain of title to try to then stop the person who's it's quitclaimed to from Bill coming in and saying, oh, well, now you got to delay the whole proceeding. I didn't have notice, et cetera, right? Because that's the worst, is dismissing your proceeding, starting the clock all over, and then going through attending court 2 times before you get somewhere. The other question that we have is relates to OMA. So Open Meetings Act questions are obviously a constant concern for townships. And the question relates to what if boards or commissions in a charter township, and this actually wouldn't matter whether it was potentially a charter or general law township, can phone in and be allowed to participate and be part of the quorum. What's basically the result? Is that still a proper meeting? So it's an interesting question, and I think it sounds kind of like the obvious way to look at it would be under the Open Meetings Act, right? So we look at the Open Meetings Act, we would figure out what would be the requirements for participation. The Open Meetings Act, the position that it's been read is that for years it's silent as to whether you could phone in, be in attendance through video conference, or otherwise physically be there. But there's been legislative efforts over lots of years to basically require that for that public transparency, the position is taken that elected officials should be present and they should deliberate in person, right? So that's kind of been the general intent of the statute, but from a technical perspective, it's never been prohibited to call in and potentially have a member participate by phone. The interesting part, 2 things there. One is that this question actually asks what would be allowed to participate as a quorum. Well, so the quorum is not a legal requirement set by the Open Meetings Act. That would be set by the General Township Act or by your Charter Township Act, which is basically the statutes, right? And the statutes only require that the quorum be available at the meeting, and you have whatever the quorum is, the number based on your board. So I read that to say someone could call in and they would still be available to participate in the meeting. Therefore, you could also still have a quorum as required under your statutory requirements. And then the Open Meetings Act is silent on the issue. So potentially, you also do not violate the Open Meetings Act by calling in. Now, that was what I used to say for years. There's a slight twist on that now because during the lame duck, they introduced an amendment to the Open Meetings Act that allows veterans to appear by phone. So it's specifically written in the statute. The interesting part was when they made that legislative amendment, they didn't say anybody can appear by phone. They said veterans. So now the question becomes, they're silent as to whether the rest of us can appear by phone. So do we read the fact that they specifically allow veterans to appear by phone, that the rest of us have to be physically present to satisfy OMA or not? So that question is still out there. I would say since it's in the gray area, you probably can continue the practices as you have. And the only thing that you would want to then do is amend your policies and procedures to address the attending of a veteran to a meeting. Yes? Oh, active duty, correct. Sorry. You're absolutely correct. Okay. Let's go down here. We still got a lot of questions about roads, Bill, but you said you didn't want to redo your presentation. You're still standing by that?
What do you throw it at me?
Okay. Well, we can come up with maybe something different here. So, as it relates to the roads, the general question relates to how the earmarking is working. So eventually the issue of we have the state making lots of proposals to earmark funds, but there's some concern as to whether that would actually get back to the locals. And so it was a question of how township officials, whether they should try to work with their local county road commissioners or whether there was a better route, a different path of elected officials that they should potentially work with to earmark those funds to go to the local areas as opposed to maybe the cities.
Well, this just gets back in front of the legislature, right? And this earmarking of funds that we always thought, for example, that the education funds were only going to be used for education and the road funds for roads. But our good friends in Lansing who represent us frequently play fast and loose with those funds. For example, what's happening right now, the education funds are getting diverted to roads. The road funds are getting diverted to other purposes. And what ends up happening right now in Lansing is that the squeakiest wheel is getting the grease, and the grease is coming from other funds that should have been used for some other purpose. The answer to the question obviously is not something that's within any of our control individually as townships or even as counties. It lies within the control of the state legislature, and I think we need to insist when and if we do pass new legislation that is going to, say, increase the gas tax maybe, or come up with some other way to pay for roads, we do need to insist that it has some sort of a hard trust earmarking on it so that it can't be used for some other purpose. Can we do anything about that individually? Probably not, but this is something that here we are all together under the umbrella of the MTA. That's something that I think we have to use our state organization to go to the legislature and demand happen.
Okay, Matt, this is an interesting chain of command question as it relates to kind of the zoning building question. So we've got, actually in assessing. So I'll add in here an additional official. So we have the assessor, building official, and potentially then maybe a zoning administrator, and I guess we could even add in a code enforcement officer, right? So all of those potential either officials or employees are serving for a township to carry out that business. Are they under the direct supervision of the supervisor? I'm guessing this is either a zoning administrator that asked this question or a supervisor, but are they under the direct supervision of the supervisor, or do they answer to the entire board?
Yes.
I hope we answered whoever's question that had that. I'm sure they know exactly who they answer to now.
So in the day-to-day, the supervisor is your legal agent, and the supervisor then would control and kind of direct your day-to-day when you're responding to specific issues and allocating work and things like that. I would look to the supervisor as the direct report there. As we add in more officials, if you've got a large department, then you might have a management team, and you might even have a more complex management structure, which then, of course, that'd be taken care of sort of in your org charts and all that good stuff. But yes, there is still some answerability to the township board, but those are going to be generally your larger policy questions. What kind of budget are we setting? We're going to be voting on budget. Is there a litigation risk? Is something happening with your zoning administrator in an event barn, perhaps, where there might be a litigation risk, and we need to be informed about that and contemplate whether we want to initiate litigation or play defense when litigation comes up? Well, that's more of a township board question. So for large, kind of high-level questions, yes, you'd still be getting your township board involved. But for your day-to-day management of those employees, I would look to the supervisor on those.
Okay, and then Kyle. So we're going to talk about expenditures. So Township's willing to spend some money. It looks like maybe even have some holiday parties now. They're gonna benefit all of the zoning administrators, assessors, and people we're talking about.
Yeah. So this question it's a common question, and it's it's sort of a simple answer, but then the answer is so broad where it makes the interpretation kind of difficult. So essentially, public expenditures have to be for public purposes. What exactly is a public purpose is, it's nebulous. It encompasses a lot of things, but if you think about traditional kind of government operations, if you spend money to fix a water main, that's a public purpose. It benefits everybody. It doesn't benefit just a few individuals. So when you're looking for guidelines for these kind of holiday parties, you think, what's the value and what's the public purpose here? And for just a pure holiday party for staff, there's probably not a public purpose there. It's benefiting kind of just staff. Some ways around this potentially are getting sponsors for an event and having the sponsors pay for it. There's also kind of established law where you can have a formal training and then also kind of associate that with some meals and kind of what we're doing here, but not necessarily a holiday party, but a little bit of.
So you could do crowdfunding, hire us to teach you something, and then we'll bring lunch.
Right. So that's where it kind of stands. So the holiday part, unfortunately, the state law does not let us appreciate our employees as maybe we should be able to.
On that topic,
Yes.
what happens, I know there are townships that pay for lunch and dinner for election inspectors during the election.
Well, I would actually say, that's why his analysis under the public purpose is an important question, because you really there are potential services that you could pay for, like maybe the hours that you make them work justifies actually bringing that in and paying for that, and you're still providing a public service, right? It's not like you're just celebrating Christmas or something, right? So that's why it's super important, as he noted, it's a factual indication. You got to look at the circumstances. There are court cases that provide no better direction on what public purpose means. So we look at all these cases and then we just throw a dart and guess. Or maybe we roughly know. But I would say that probably sounds fine. I'll stand on that one. Okay, so I got this question about personal property tax, which nobody likes talking about, but I think this person's got a really good mindset on this one. I like this. How many deputy treasurers and treasurers are in the room? So how many people have seized personal property for delinquent taxes? Okay, those two people are awesome, because this is such a cool thing. I don't get it. So I have been doing delinquent personal property tax for so long, and as soon as I read it, I couldn't believe the fact that the statute allowed you to provide some simple notice and then go in and seize people's property. We can put tags on it, we can have an auction, sell it, make some money. It's unbelievable. Everything else that we do, we have to go to court for, and I just can't believe we don't exercise it. This person is a little bit more twisted than I am, because they want to take it one step further. So the question that they pose is, they said, hey, this person who's not paying me delinquent personal property is charged a special assessment on a private road. And of course, they're paying their special assessment payments to keep their private road maintained, but they're still not paying me my delinquent personal property. Can I take the revenue from the special assessment private road they're paying and then attribute it to the personal property tax bill? I think that's genius. Now, clearly unlawful. You cannot do that. Don't do that. But I think that's genius. That's the stuff that when I wake up in the morning, I would try to think of, So I absolutely appreciate the question. And I just have to say, I think it raises the point that for those of you, honestly look at the personal property tax collection. There are a lot of municipalities that we look at that have a pretty good significant amount. Maybe $10,000, $45,000, $50,000 of delinquent personal property, and we get calls every couple of years to basically go in. There's an ability every 5 years. Treasurers know this, right? We can petition it and get it off the tax rolls. But honestly, if that individual, especially who's owing you that, is still in your jurisdiction, there's some extreme power to be able to go in and seize personal property to get it paid for. Now, the one thing that I will add in about the person thinking about taking these special assessment revenues, we could potentially actually file an original action. So I think the seizure route is really nice, because you can take their property and they start listening to you pretty quickly. But We could go to court and we could get a judgment, and then once we got a judgment, we couldn't take the revenue from the special assessment, but we could actually figure out where they're storing the money before they pay you on the private road special assessment, and we could go garnish it there. So there's still, I mean, this is the thing that treasurers enjoy, right? All these ways to try to, these interesting ways to collect it. So I really appreciate that one. Okay, so Jake, we run into this question as well, because obviously as townships we're sitting here, we know that we all have limited budgets and we can't always go out and enforce maybe every ordinance to the aspect that we would like to, right? We're not actively policing in most townships. We're complaint driven or otherwise responding to applications and requests. So is there a potential liability or a cause of action that exists against townships to be joined in litigation to enforce their own ordinances?
Yeah, you could file a mandamus action.
And then what's the potential, okay, so I guess just to repeat that, so if you have a potential obligation to enforce an ordinance,
Right.
you could have you could be included in a court action.
Yeah,
And the judge could basically order you to enforce your ordinance.
yes.
Okay. And nobody seems surprised. Either you're silent because you're just like, wow, we have so many ordinances we don't enforce, or I don't know. Okay, so then is there a way to potentially recover attorney's fees in a mandamus action of this type?
There is. It's not a foregone conclusion, but the Revised Judicature Act, which is what governs mandamus actions, provides that damages and costs may be awarded. So there is a potential that the court could award.
Okay, and then for those who don't go to court often, it's like we rarely find a court that will award attorney's fees. So even though it is in their discretion, for whatever reason, if there's any judges, I apologize, but it's extremely difficult to convince them that any actions are egregious enough or frivolous enough for us to get attorney's fees. So I would say the potential liability in that type of situation of getting attorney's fees is probably pretty low. But when you get the cause of action and you get the complaint and you send it to us, we can take a look at it, and I'm sure we can probably figure it out before anything arises. Okay, Matt. So we're in the process of codifying ordinances, and we've adopted ordinances that so there's references in the law that need to be updated. Can they update the references in the existing ordinance, or do they have to pass an amendment stating that they replace that or change those amendments? And I think there's a couple ways to probably read this question, but
Right. So what I would recommend there is making the amendment so you're updating the reference and you're going to be accurate when you bring your codification in. The nice thing about the Codification Act is in this specific instance you can amend by reference to the title only. So we don't have to go reprinting the whole code that we're codifying. So you can just note that there are amendments to get the right statute referenced in those titles. But that's going to be helpful because then once you have your act recodified, you'll be able to find the right answer, the right statute more quickly, right? Both for your citizens and when you're trying to figure out, what your own ordinance is bringing to bear here. The flip side of that is typically when you're incorporating statutes by reference, you're going to say as amended. So if there is a statute that you missed, that you didn't get the newest not recodification, but the newest act passed by the state, as long as you're going to be able to reasonably identify the statute that has been incorporated by reference with these as amended languages, you should still be able to enforce it. So as a best practice, I'd recommend updating those citations to the best you can, but if there's something you miss, we should be able to deal with that as well and keep that enforcement in place.
okay, so we've got here a good question about what looks like internal strife among the board. So hopefully all the board members aren't in the room right now. Otherwise, somebody's going to look maybe a little embarrassed. I don't know, but so I guess Bill, if you can address this, can the township board dictate how the clerk does her job? And there's some examples provided, and I think as I list the examples, whoever the board members are in the room, it's like we're going to figure out what township this is. So examples include the clerk, it looks like 2 checks for the same employee saves them for taxes. So it looks like something about issuing 2 checks. What about office hours? Are they not allowed to have a township laptop or to work at home as opposed to forcing them to hold office hours? What about ignoring the clerk's request for a pay increase? Come on, guys. I mean, clerks do a lot. I can't believe you'd ignore pay increases. Supervisor looks like is meeting with other trustees and then potentially denying or otherwise including new rules on clerks and treasurers either when they come back in.
Yeah,
And I would tread lightly. I can tell you that.
Thanks
Yeah.
for handing me this. It's about to, this is about to explode in my face. So what I will tell you is that there actually is some case law on the issue of the independence of clerks and to what extent can they be controlled by the township board. And it is a fun case to read. I believe it came out of Green Oak Township. I think that was where it came from. And what the court wrote an opinion which basically said all you people are pinheads on both sides, and we can't believe that we're required to actually resolve your bickering. But what the court ultimately did say was that the clerk, if that was his or her desire to work out of his or her home, was entitled to do that, wasn't required to come into the township hall and have office hours there. I don't think that was a really good resolution of the problem. I think we're all sorry that particular case got brought to the Court of Appeals, because now we know that the answer is that there is a certain amount of independence, and that can lead to situations where a clerk might just say, you know what, I'm not even going to play with the rest of you township board members. I'm going to do everything out of my house, and who cares whether or not I'm serving the people. Ultimately, what comes out of it and how those things have to get resolved is at the ballot box. That's the answer to it. I really think it's a bad idea to start filing lawsuits among yourselves. And even if there may be or may not be clear legal answers to those divisions of authority, it's almost always better to try to work your disputes out in a collegial way, because it does get really messy when you start taking your disagreements between board members into the forum of a court. So that's my advice on it, and I hope I was able to walk a very careful line there without taking sides.
Okay, so a good question that we had about fire authorities. Now the question was, what do I need to be aware of during the planning of an impending fire authority? I read that to say that they're looking at establishing something. You need to be aware of everything. So it's a tough forum, I guess, to answer everything. But we've given this presentation probably actually 2 or 3 years now, and it's like an hour and a half long. But I did come up with some general keywords to think about, and I'll just go through those real quickly. So if you're looking at a fire authority, do you like the other units that you're going to be working with? Okay, it's super important, because we've seen a lot of units that have been in place for maybe 10, 11 years, and then there's changes in the boards, the rules aren't properly set up in that authority agreement, and it starts to fall apart. So that goes to my first point. Look at the composition of the boards. Look at how those members are selected. So are they coming from the boards of each incorporating unit? Are they going to be appointed by those governing bodies? Those kinds of issues. What's the authority that you're going to give this fire authority? What kind of operations can they carry out without the incorporating units being involved? How are you going to handle budgets? How are you going to handle auditing, issuing, paying bills? Who's going to be the FOIA coordinator? Who's going to respond to those records? How are you going to handle cost recovery? You can see the list goes on and on. Allowance for contracts with other units, looking at what type of employees or individuals would you create as far as administrators in the authority process. A lot of times you'll be able to handle that through the budget. But that's really the biggest issue that then comes about, is the budget, approving it, and the question then becomes the most important part with fire authorities. which is how you determine the cost of the individual incorporating units. And so there's a lot of materials out there with different ideas as to taxable value, fire runs, a hybrid of all of that together. But just make sure that you're extremely comfortable with that and that you look as a long-term plan. Generally, if what we see is if all of the townships are kind of the same size, same type of per capita, same taxable value, it all seems to work out. There aren't much issue. What starts to happen is with you get 4 or 5 municipalities together, one township's got a much higher taxable value, which is the formula they use to figure it, but then they're getting 80% of the runs, but still only paying 50% of the revenue, right? And then the other municipalities now think it's unfair. So there's a lot of literature out there about hybrid formulas. Especially take your time to look at how you're going to determine who's going to pay for and apportion those costs. There is an ability to levy millages as well, but you could potentially, that would be another thing on the table, is to think about what you're going to allow that authority to do and whether you want it to have that ability, or whether it's only going to come from basically pay-ins or capital contributions from the incorporating members. Let's see here. We'll try to do I guess 2 more questions real quick. Did that question? Okay, so Matt, what gives the township the right to force a resident to hook up to a utility? I think probably especially really water and sewer utilities. And it's really an interesting question in the last few years, because I'm sure you've all heard of PFAS or PFOAs, so there's been a huge issue with those. And of course, you've got the movement of those plumes through our water aquifers. And it's been an issue where areas that are on water, that it moves into areas where there's wells, and then there's questions of how you're going to extend those public improvements, whether then who you want to require to attach, right, to basically then pay for or offset the cost of that. So it's really been an interesting conversation as of late with the environmental concerns.
And piggybacking exactly on that, you can look to the health, safety, and welfare. I mean, I think you play that angle and talk about, there was some insinuation that maybe they already had an existing utility. Well, you need to make sure that it's staying healthy. It's not just about that one home. It's about the whole distribution network. It's about the whole community, someone who might buy that house in the future. But also specifically, townships have authority. And here, what kind of utility? If we're talking about water and sewer, then we've got specific authority to create those distribution systems and have those installed and utilized. And then you can look to your policies and procedures of continuing service, that you've got rights to maintain and improve those utility lines. So if we're talking about improving your existing line, and he doesn't want the improvement, well, it's part of the policies and procedures for continuing service. So depending exactly on what utility means here and the factual circumstances, there's a lot of different ways that you could get at it to get your improvement made and get that house hooked up.
Okay, and then Bill will ask the last question. We spoke about it earlier as it relates to public capital improvement funds. So what can you do with the public capital improvement funds, and are there limitations on what you can spend that money on?
So I assume that what the question asker is referring to is what's called the TURF fund, the Township Improvement Revolving Fund. It is a kind of capital improvement fund that the law, Act 188, allows townships to create. And you can take money out of your general fund and put it into a TURF fund, or you can fund it through special assessment districts that have excess earnings, and you can put those excess earnings, if they're less than 5% of the total special assessment district, you can put those into your TURF fund. Once the money goes into that Township Improvement Revolving Fund, there are a few rules that apply. One is that the total fund cannot be equal to more than 2 mills of your township's taxable value. But up to that amount, you're allowed to hold that much money in that fund. You can then take that money, which is in the Township Improvement Revolving Fund, and you can use it to make other improvements in the township. And the improvements that are allowed are any of the improvements that are addressed by Act 188, which is the Township Improvement Act. Includes water, sewer, roads. improvements to lakes. There's a whole list of improvements that can be undertaken under that act, and you can use your turf fund in order to fund those. One really great use for that, and I don't see a lot of townships doing this, is you put your money in the turf fund. You then use that money to basically lend to a special assessment district that perhaps wants to build an improvement to their road. They then, the special assessment district, pays the township back that amount over time through special assessments with interest, and that interest can be as high as 5%. And one of the things I see that being very attractive for is the ability to get not only leverage your money to make improvements within your township, but then also to be able to earn a higher rate of interest on your funds than you would be able to get if you'd put those funds into a bank, which obviously in this day and age is paying a very low amount. So you really have kind of a multiple benefit from doing that.
Okay, so and then we're going to select randomly based on the individuals who submitted questions, who's getting the Fitbit, and then also we'll award the individual who signed up for our e-letter. And since I don't have like a nice little bingo ball, so I just, for complete transparency, I've got my Google random generator number, so I just punch everything in here. This just like figures out all the science. All right, I got number 29. We'll build some suspense, not that anybody's...
Drum roll.
Right. Carrie Milburn. Is Carrie Milburn here? Congratulations. And then let me do this again for the e-letter sign up. Okay. And then we have Julie Beardsley. Julie Beardsley present? Okay, we can still clap. I'll mail it to her. All right, perfect. All right, we're all set. Thank you guys. Appreciate it. If you we'll be around the rest of the afternoon, so if you need us, feel free to stop in.